The cash for queries allegation against Trinamool Congress's MP Mahua Moitra has spiraled further. The Lok Sabha Ethics Committee held its first meeting on the case on October 26th, and Supreme Court lawyer Anant Dehadrai has appeared before the panel and recorded his statement on the matter. After Dehadrai, BJP MP Nishikant Dubey, who levelled the bribery allegations against Moitra, also appeared before the committee. It all started when Dubey had alleged that Moitra asked questions in Parliament targeting the Prime Minister and Home Minister in exchange for gifts and cash from businessman Darshan Hiranandani. Though the committee is conducting an inquiry into this, it cannot recommend the initiation of a criminal proceeding against an unethical act. So if charges are proven, then what is the next step? And what are the rules if this is actually a violation? We try to dig out some details in this video. Why does the Constitution give immunity to lawmakers? Let's first understand that parliamentarians enjoy immunity for their actions and speeches within the House. However, the leader of a House can suspend or even remove a member for unethical behavior. This power comes from Article 105 of the Constitution of India, which allows freedom of speech in Parliament. So, to maintain this freedom, MPs must not be prosecuted in a court of law for what they say within the House. Here's what Article 105 Part 2 says. No member of Parliament shall be liable to any proceedings in any court in respect of anything said or any vote given by him or her in Parliament or any committee thereof. The same applies to members of a state legislative assembly, as per Article 194 of the Constitution. Now, the question of whether an MP can be prosecuted in the court of law for taking a bribe and speaking or even voting on a particular issue has been considered by the Supreme Court twice in the past in cases that are 25 years apart. The first time was in 1998 when the Apex Court ruled that MPs were immune from prosecution in the court on bribery charges for their speeches or even a vote in Parliament. The case pertained to allegations that some MPs were bribed in order to help defeat a motion of no confidence against the Congress party-led P.V. Narasimha Rao government in July 1993. The second occasion was in 2023 in a case against Jharkhand Mukti Morcha leader Sita Soren, who allegedly had accepted a bribe to vote for an independent candidate in a Rajya Sabha election of 2012. Let's look at the Narasimha Rao case. The Congress had emerged as the single largest party in 1991's general election and had formed the government with P. Narasimha Rao as the Prime Minister. Although at 251 seats, it was 14 seats short of a simple majority. Ajay Mukhopadhyay, a CPIM MP, had then introduced a no-confidence motion against the government in the Lok Sabha on July 26, 1993. This during the monsoon session. The motion was subsequently defeated with a slim margin of 265 votes against and 251 in favour of the motion just 2 days later. Opposition leaders had approached the Central Bureau of Investigation or CBI, alleging that the ruling party had paid bribes to MPs to vote against the motion. They insisted that the matter be prosecuted in a court of law. The CBI then had registered cases against MPs of the Jharkhand Mukti Morcha. The case ultimately reached the Supreme Court, where it was referred to a 5-judge constitution bench. The Supreme Court, by a majority of 3-2, held that parliamentarians are immune to prosecution on bribery charges for their speeches or their votes in Parliament. This, according to Article 105, Part 2, which confers immunity to them. However, the minority held that immunity granted under these laws would not extend to cases where bribery is alleged for making a speech or even voting in a particular matter. The Sita Soren case. In 2023, the Supreme Court said that it would reconsider the judgment in the 1998 case involving Narasimha Rao government. A bench of the court said that this is in relation to the case of bribery allegations against Sita Soren, a leader of JMM, which was also involved in the Narasimha Rao case. It was alleged that during the 2012 elections to choose 2 members of the Rajya Sabha from Jharkhand, Soren, a member of the Legislative Assembly, had accepted a bribe from an independent candidate to cast her vote in his favour. However, she did not vote in favour of the alleged bribe giver, who then filed a complaint against her, which culminated in a charge sheet against her. Soren moved to the High Court to quash this charge sheet. However, the court refused to do so, stating that she had not cast her vote in favor of the alleged bribe giver and hence was not entitled to protection. Considering the similarities with the Narasimha Rao case, this case was placed before the constitutional bench of 5 judges, reference to a 7-judge bench. In September of 2023, the case came up for hearing before a 5-judge bench, which was led by Chief Justice of India, D.Y. Chandrachud. The 5-judge bench decided to place the case before a 7-judge bench with the intent of revisiting the ruling in the Narasimha Rao case. The apex court made the references on 3 grounds. The intent behind granting immunity to lawmakers is only to enable free speech in Parliament and legislature. However, it may not be for immunity from criminal proceedings for a violation of criminal law independent of their rights and duties as Member of Parliament or a state legislature. Second, what would happen if a lawmaker received a bribe not to speak on an important issue or not to cast their vote on an issue? Would the immunity still apply? Third, if a lawmaker accepts a bribe and subsequently does not fulfill the purpose for which that bribe was taken, would it still then be an offence? The 7-judge bench heard this case at length on October 4th and 5th and has gone ahead and reserved its judgment.